being enjoyed by the community, we should either increase and not reduce. But review in this instance can be both ways. It can be review upwards or review downwards. I think it's something that we should take cognizance of. Excuse me. Now, let's look at the statutory requirement generally. Now, when we're looking at statutory requirements, generally, we are going to see what the law provides. But the Ministry of Mines and Steel Development produced what we call guidelines for the production of community development agreements in the solid mineral sector, 2014. So this is one regulatory document that lawyers operating in this area need to take a look at. It gives you an idea of how to go about the process of negotiating and drafting CDAs. So I will urge my colleagues to take a look at it. I say guidelines for the production of community development agreement in the solid mineral sector, 2014. What we can distill from that document is that it provides what should be the key elements of a good CDA. And that is, one, it has to start, there must be a time frame. I've already talked about 5 years, subject to renewal or review, as the case may be. So if you can't have a CDA that is endless or indeterminable, as it were, it must have a time frame. Is it 5 years? That period must be stated. You must also agree that during the process that these issues between the companies will be concluded within that period of time. There should be stakeholder participation, that is, those who are affected by the company's operations, particularly in the community involved, should be part of the process. So there should be stakeholder participation. Representatives of the company must be there. Representatives of the community must also be there, so that these all shades of opinion are taken and their issues are considered. There has to be capacity building of the participating stakeholders. Now, this is very important, and I will urge my colleagues, when they are advising mining companies, for instance, one of the first things you should do is to ensure that the representatives of the companies that are negotiating have the capacity to do so. So some preliminary form of education on what CDAs are, what they are designed to achieve, and all of that should be extended to the representatives of the company, so they can from the beginning know what it is that they're supposed to be involved in and the kinds of demands that they can make. If this capacity is not built, you end up with people who really do not understand what the issues are at stake, and they may make unreasonable demands on the company. Also, there has to be an identification of the qualified community. This is very important because the law envisages that is that communities that are impacted by your mining activities are the ones that should benefit from those operations. So care must be taken to identify which community qualifies. And in this respect, it has to be a community that is most proximate to the area of activity. If, for instance, the mining company is located around Wuse, for instance, it is inconceivable that a community in Guzape will be part of a qualified community. It has to be communities that are around the Wuse area that will be affected if the activities take place. So this must also be something that lawyers must guide their companies clearly, so that they can identify that at the beginning, so that they can be able to manage the level of demands that you get from communities. There should be representation of the funding of the project must also be there, because there has to be some fund put aside to ensure that the CDA, once agreed upon, the projects agreed upon can be implemented easily. The obligations of parties must also be clearly set out. It's not just the company that's undertaking to do ABC for the community. The community must also be able to undertake ABC or CDE in favor of the company. So it's an exchange of reciprocal obligations on the part of the host community and the companies involved. This must be taken very seriously. And of course, grievance, remedial measures, dispute resolution must also be something that must be agreed at the beginning, because we are envisaging a long-term relationship that can last between 5 and 35 years or more. And therefore, it's difficult to say that within that period of time, there can be no dispute. Obviously, there will be dispute between the parties within that time frame. How do they resolve those disputes? What mechanisms would they deploy towards resolving those disputes? So the dispute resolution mechanism must be clearly understood by the parties from the beginning. Of course, monitoring. Monitoring is important in the sense that it enables the parties to know how well the agreement is being performed, the obligations there, and where there are difficulties, those they become very early warning signals for the parties to deal with the matter as should be dealt with. So monitoring is an essential ingredient. Let's proceed to look at other regulatory requirements. Apart from the Minerals and Mining Act 2007, the guidelines of 2014, you also have the regulations, Nigerian Minerals and Mining Regulation of 2011. And if you look at Regulation 1993, it also provides what those who are engaged in community development agreement should actually look at and ensure that it's contained in the agreement. They are basically environmental compliance issues and so on, and programs that ensure that environmental impact assessment has also been carried out before the project commences. Now, let's look at, having talked about what the law requires us to do, the guidelines and the regulations, we can summarize by asking ourselves that what are the hallmarks of a successful negotiation of a community development agreement. Now, if you see in the slide we have before you, we have a community of people sitting together. Here you have women, you have men, you have young people, you have old people. So the CDA process and its negotiation envisages that it's an inclusive process that involves all the parties, all the interests in the community. You cannot have a CDA negotiation that involves only the male population in the community or only adults or elderly, as the case may be. No, all shades of opinion must be taken together so that when they make a demand, it will be one that represents the aggregate interests of all segments of that community. So it has to be an inclusive process. There has to be clarity of objectives. People must really say what they want to achieve through this process, and that must be clear. For instance, if you have a clause that says that the community will provide amenities for the benefit of the community, that is nebulous. What are amenities? How do you define the benefit of the community, as the case may be? So at all times, care must be taken to ensure that whatever is agreed upon is clear and parties understand exactly what the nature of their obligations under the agreement. There should be a demonstrable commitment on the part of the parties to carry on with the respective obligations there. So don't just promise for promise sake. Now, again, our colleagues here must take this very seriously. If you are advising the mining companies, again, you must tell them that, look, whatever they commit to, whatever they agree to, they must be committed towards providing that. So you do not just say you are going to provide a classroom so that the community will be happy with you and allow you to commence operations. You have to be committed to doing that. That is very important. Also, if you are representing the host community, you must also be committed to the obligation. For instance, if one of the obligations is that you will ensure that the premises of the company is protected or is secured, from theft or any other invasion, the committee must be prepared and committed to providing that, carrying through with that obligation. If there's no commitment, then this process cannot work. There should be an effective governance arrangements of managing the relationships between the parties, both the host community and the mining company. So what is advisable at all times is to have a committee, a standing committee made up of representatives of the company and then representatives of the community. That will be the governance system, so that they can meet from time to time to decide on issues that come before them. If it's in terms of request, they can consider whatever request that the committee is making and agree as the modalities as to how to deal with the issue. If there are disagreements, this first layer of governance can also be able to look at it generally. So it's very important to have a governance arrangement in place. I've already emphasized the need for monitoring. I also want to emphasize the need for flexibility. If you have a system in place that is flexible and adaptable, then it can deal with changing situations. And I give you an example. For instance, if in the community development agreement, the company, the mining company says, I'm going to provide borehole for water in the community, for instance, and only for you to discover that maybe the place is a limestoneous area and they cannot strike water. The community cannot continue to insist that, look, you must provide the borehole. We agree that there has to be a borehole. Now you will find out that under such circumstances, it will become impossible for a borehole to be sunk in a place where there's no water. So in that case, the community should be flexible enough to allow for a closed substitute or something else that can be done by the host company to actually show that they are willing to assist in the direction that is. So flexibility and adaptability are also a very important ingredients that we must take on board when dealing with community development agreements. So having said that, I want to quickly summarize what are the obligations we expect mining companies to meet when they conclude CDAs. The law envisages that companies should be able to provide educational scholarships, apprenticeship, technical training and employment opportunities for the indigenes of the community. The law also expects them to be able to provide financial and other forms of contributory support for infrastructural development and maintenance of such as education, health, and other community services like road, water, and power. And the law envisages assistance with the creation and development of small-scale or micro-enterprises within the community, that is to empower them. It also envisages agricultural support in those areas, and of course, methods and procedures for environmental and socioeconomic management and local governance enhancement. These are the issues for which the law expects that the communities can request the mining company to provide for them. And these are the range of issues that the mining company expect that host community will demand of them. And we will see how this actually plays in real life, whether in real life companies or host communities actually adhere to what the law envisages us to provide. But if you look at the whole range of obligations that I've talked about here, one thing is striking, and what is that? Is that whatever it is the company is asked to provide must inure to the benefit of all members of the community. It does not deal with issues that deal with the narrow interests of either members of the technical committee or narrow interests of community leaders, chiefs, and so on. So we have to distinguish what will benefit the whole community from what would benefit perhaps their chief or the negotiating committee, as the case may be. And we'll see how this plays out in the course of the discussion. So this slide now generally talks about the whole gamut of obligations that host communities have accepted and the ones that mining companies have also accepted. What you have before you in this slide actually represents real life. And I was able to distill them from 4 community development agreements that have been concluded within the Abuja area, Durumi, Piakasa, and so on. There are 4 main community development agreements that were concluded in this area, and I was able to distill this obligation from them just for us to illustrate what the point I made earlier. So if you see host communities in terms of the obligations that they have undertaken to carry out, they say that they will not sublet any land covered by the lease without the consent of the mining company. This is the host community promising the mining company. They will ensure that mining operations are not disturbed. They will ensure that right of access to the mine site is also not disturbed. They also promise to assist in the provision of security to the mining company, and also that they shall not join or align themselves against the mining company in any litigation or arbitration with a third party. So here is a host community saying that, look, this mining company we like what you are doing. This is what we are prepared to do for you. We will not allow people to disturb your operation. We will provide security for you. We will not gang up against you. We will not lease any land that that's covered by your lease. Now let's look at what mining companies have also promised host communities in this area. To construct roads for them, construction of school classroom blocks, provision of health clinics, provision of police posts, employment of indigenes, provision of water through borehole, provision of electricity, provision of chippings fortnightly. Now, if you look at, if you consider these obligations that I've talked about on the part of the host community and on the part of the mining companies, you see that those obligations are the ones that can be enjoyed by every member of the community. If they provide roads, every member of the community will enjoy health clinics and so on. But there were also other obligations that were curious, and I've also highlighted them, which may not necessarily be for the benefit of all members of the community, but nonetheless, the mining companies agreed to discharge those responsibilities, and we'll come to that later. But let me quickly just run through some of them. One of them was provision of chippings fortnightly. This was supposed to go to the committee that negotiates, that standing committee I talked about. 2, payment of stipends to the community leader. Then provision of car for the community leader. Then payment of monthly governance allowance of 500,000 to the community. Of course, fencing of the chief's palace and to build offices and for the comfort of the chief. So you can see in these last 5 obligations I've talked about, they are not obligations that are not to the benefit of the whole community, but to certain class or group of persons, particularly the members of the negotiating committee or community leaders, as the case may be. So you have to ask yourself, is that within the contemplation of the law? Does the law contemplate that the agreements, when concluded, should contain obligations that tend to benefit certain individual or certain class of persons apart from the general community? So we'll have to look at this. I would say no, that's not within the contemplation of the law, but a prudent businessman is faced with reality, and sometimes he has to adjust to the reality of the situation. And I've asked people that, what if the chief says, if the people of a particular community say that, look, the happiness of the chief is our collective happiness. Therefore, if the chief is made comfortable, it means we are comfortable. Or if they say that, look, if the chief is happy, his wives are happy, the mining company should give the pay some stipends to the chief's wives so that they can be happy. They will make the chief happy. If the chief is happy, then the community is happy. So it is for our common good. I mean, some communities can say that. So when you are negotiating, you have to take a look at all of this and ask yourself whether indeed that is within the intendment of the law. So I've now asked some questions, and I think this is very important because this whole process is expected to play out without difficulties, but it is based on certain assumptions, and these assumptions, for me, they create a lot of difficulty and challenges, both for the mining company and for the host community. It would appear that the requirements of the law are premised on the following assumptions. 1, that the representatives of the host community have the requisite capacity or will acquire the necessary skills to carry out arm's length negotiations with the mining companies. This is not always true. Sometimes they will not have that skill. And that's why I said at the beginning that there's a need for us to advise our clients, if they are the mining companies, to quickly try to improve the capacity of those negotiators so that they will understand what it is required of them. 2, there's also an assumption that the representative of the host committee will achieve consensus on their common needs and expectations from the host community. So there's this assumption that those representatives actually, what they are demanding from the company is actually what the people have said is their common need. It may not always be true. Maybe you might have a community that water is a great problem for them. If water is provided, they will be happy. But the representative can come and say, well, what we want is not water. What we want is a television station to be sited in our community. So you have to ask yourself, to what extent will they represent the people, and to what extent are they actually advancing the common interest of the community? Another assumption is that the narrow representative of the host community have the best interest of the community at heart rather than their narrow selfish interest. It's also not always true. If you remember some of the obligations I talked about, where they said money should be paid to those members, to representatives, or that a quarrying company should give them chippings fortnightly for them to sell and make money for themselves. That certainly cannot be for the general good of the community, but for the members of the representatives of the community who are members of that committee. So this can also happen in real life. There's also an assumption that the mining operations will be profitable and the company will be able to generate enough revenue to be able to provide those things that they have promised the host community. Again, this might fail sometimes and may not be able to happen. And then, of course, there's also an assumption that the negotiations taking place are good faith negotiations, and sometimes it's not in all cases that those negotiations are good faith. So I've asked the question, how true are these assumptions? And the answer is clear that it's not in all cases that these assumptions are true. And if the issues are not properly thought out and negotiated, it might occasion difficulties for the parties involved in the process. So the critical questions to consider now, this is addressed to our colleagues, lawyers, who will serve as transaction advisors to the various companies. So what are the critical questions that you consider while guiding your clients around the table? 1 is to ask yourself, is there a correlation between the type of mineral to be exploited and the nature of obligations assumed by mining companies? Here, what I'm trying to say is that, for instance, would the CDA concluded by a mining company engaged in gold be different from a mining company engaged in queryable minerals? I think you need to consider this, because if a company is mining for gold, there's already a lot of expectation because of the high price of gold. There's already a high expectation on the part of the community that, look, the company should be able to do more things for us. So there's a likelihood that they will demand more capital intensive items to be provided for them by the community. There's also a tendency that the relationship will be for a longer period. Therefore, while negotiating, you have to have this at the back of your mind. What can we do to continue to have a continued acceptance by the host community while our operations last? These are things that we need to look at very closely. I've also asked that, can the disparity in the obligations be rationalized on the different needs of the host community or on the negotiating capacity of their representatives? Again, this is very important, because I talked about the fact that you have some making different demands. Some are for the general benefit of the people. Some are narrow demands that serve interests of a few. Based on the negotiating capacity of those representing them, or it's different. I think this can also be looked at. It's something that you need to consider while dealing with this matter. So the last one is that, how can lawyers aid host communities and mining companies to arrive at some understanding that will be beneficial to all the parties? So these are the critical questions you have to consider while negotiating this process. Now, the other thing to talk about is that agreements have been signed. How enforceable are community development agreements generally? How enforceable? So I've said here that, what is the legal effect of the breach of obligations undertaken under a CDA? If a company promises to build a classroom block for a community that is operating within, and it does not end up building that community block, what will be the legal effect of that breach? Or can breach of a CDA covenant by a mining company lead to the withdrawal of the social license to operate? So could it then mean that the company no longer accepts that kind of mining company within their domain, and therefore it has consequences? I've said, can this breach lead to a cessation of operations despite the subsistence of the license? So your license is for 25 years. 5 years down the line, you have a problem with the the host community, because you promised to build a classroom block that you have not built. Now the community members are shouting, hey, and they block the company premises and say, nobody can come in, nobody can go out. So, but you have a license, yet you cannot carry out operations. So what will be the effect of some of these breaches? So I've tried to answer the question by saying that the manifest language of CDAs indicate that there's a clear intention to be bound by the parties. So CDAs are therefore enforceable like any other contractual arrangement, because there's intention to be bound by the obligations assumed by the parties in that agreement. Therefore, it's like any other contractual agreement. So I said, if that being the case, parties can take steps to enforce the contract, and they can seek contractual remedies. They can, including the remedy of specific performance, they can ask for damages, they can, in fact, and they can seek to enforce the contract through various means, either through arbitration, litigation, as the case may be. So CDAs are enforceable. They are not just contractual arrangements like any other contract, simple contract that you have. These are contracts that have statutory flavor, in the sense that they are backed by law. And so they should be, and they are very enforceable. I only asked one question, and I think our colleagues should also take this very serious. I've said to myself that whether host communities have the wherewithal to engage in lengthy litigation with the mining company to enforce their contractual rights is actually moot. What I'm trying to say here is that it's not every community they may have the power, the staying power, to be able to say, okay, we'll litigate this matter all the way to the Supreme Court. You promised us this, you have not done that. So I also noticed that we have an equal power relation there, and maybe sometimes when the company itself is stronger than the host community, so the company can tell them, go to hell, we'll meet in court. Now, if that happens, you will also have the relationship between the parties strained. And I've said here that a mining company does not want its operations closed down, because any downtime will lead to losses or cost overruns for the company, and therefore resort to litigation in this instance should be the last resort, because of its potential to damage relationships. And apart from that, where the issues are not properly addressed, parties may resort to self-help that is not contemplated with the agreement. I've talked about where they come and block the entrance of the company and say nobody will go in, nobody will go out. So no activity takes place. That is self-help. And once that begins to happen, it creates an unfavorable operating environment for the host, for the mining company, and strains the relationship between the mining company and the host community. So since dispute resolution is important, I have talked about the fact that we should look at it. And under this law, the law envisages a 4-layer dispute resolution mechanism. It talks about amicable settlement by the parties. That is, parties should be able to sit together. That is, the mining company and the host community, through their standing committee, should be able to sit down and discuss difficulties that may arise in the course of the relationship and come up with some identified solution. Where they cannot do so, they can have a recourse to the minister in charge of solid minerals, who will serve as an arbiter between the host community and the mining company with a view to settling this matter. You will see section 116 subsection 4 of the Minerals and Mining Act envisages this kind of procedure. We also have resort to arbitration, where the parties cannot, where ministerial intervention has not been able to solve the problem, parties can arbitrate their disputes. And of course, the last one being the courts, where parties will litigate, where they are not able to resolve their matters using the other dispute resolution mechanisms that I have talked about generally. So the law expects mediation to take place, where parties are not looking for any binding precedent, but they want to take control of the process and ensure that the outcome is as they agree among themselves. This is good because where mediation takes place and the parties agree, it is expected that enforceability will not be a difficult thing because it is something that both parties have agreed to. Arbitration is also good. Of course, there's no precedent in arbitration also. Therefore, but where the dispute is complex enough that you require those to help you decide the dispute, have the requisite knowledge that can guide to make a pronouncement as to who is right and who is wrong based on their knowledge of the dispute. Arbitration becomes a very good process. And of course, the courts are there, and the jurisdiction is in the Federal High Court to deal with matters that have to go to court. Perhaps these are only matters where you need your legal right to be determined. For instance, where under the law, where you require the court to pronounce as to whether somebody is entitled to the license or not. That's a legal determination. That in that case, you may go to the court. So the point I'm making here, there are some disputes. The lawyer must sit with the company and come up with what they think is best for the company. Choose the mechanism that best resolves your dispute. If your dispute cannot be best resolved by litigation, don't choose litigation. If it can be best resolved by arbitration, fine, go to arbitration. If it's best by mediation, please do so. But the decision taking must be carefully chosen in the light of all things considered. Like I said to you before, litigation damages relationships permanently. Now, if you're going to be operating in an environment for 35 years, perhaps you want to maintain some relationship, and therefore maybe you may not want to look at litigation as a means of resolving your problem. Maybe you think mediation might just be the best way, or perhaps arbitration, as the case may be, if you're not too worried about the cost. I'm not saying anything because Professor Idonije is here, but arbitration, you all know, has also its own trappings as well. It's not as cheap as we expect it to be cheap. You have to pay the arbitrators and pay the counsels that appear before the arbitrators. Host communities, I don't know whether they can go through that process and they have the results, but I'm sure Professor Idonije will weigh in on this later. But just to say that mechanism is also available to parties in case of a dispute. Now, because we talk about dispute, we believe that parties should have a dispute resolution clause in any CDA contract. And I've chosen some here. They are not the standard dispute resolution clause, but just to show you what parties have actually put in their dispute resolution clauses in the various CDAs that I've talked about. So I say, for instance, the arbitration clause in respect of a Durumi committee provides that dispute shall be mutually resolved by a settlement committee to be consulted by the parties, and it shall compose of representatives of all of the parties. You have that. Let me repeat that again. It says that dispute shall be mutually resolved by a settlement committee to be constituted under this agreement, which shall compose of the representatives of the parties. So that is the dispute resolution clause that was in the Durumi CDA. The one of Piakasa committee says that, quote, In the event of a failure of the host community and the lessee, after several attempts to conclude a community development agreement, by the time the title holder is ready to commence development work on the lease area, the matter shall be referred to the Minister for Resolution. Now, the PIACASA dispute resolution mechanism envisages a two-layer process. First of all, it envisages the first layer where the parties are meeting to resolve it, and then the second layer where they do not, the minister would step in. The one of Durumi committee talks about just the first layer of the parties meeting together generally. So this is the kind of dispute resolution clauses that you have in CDA agreements generally, either just one layer or two layer, as the case may be. Some are up to 3 layers where they say the parties can have resort to arbitration if need be, to ensure that the issues are clearly dealt with. So by way of conclusion, let me say that efforts should be made by lawyers to avoid investor-host community conflicts, especially in the mining sector, where a conducive operating environment is a sine qua non for successful operations. And that 2, lawyers should assist mining companies and host communities to manage their expectations to avoid breaches. The key is not to promise more than you can deliver. And then 3, where difficulties arise, early consultation and disclosure are necessary to prevent conflicts. And of course, finally, that good faith implementation is needed for overall success of the mining venture. I thank you very much for listening. I will take comments and questions if there are any, and I would like to hand over back to the moderators. Thank you very much for your attention.
Thank you so very much, Prof, for this edifying information and the great wealth of knowledge gathered today. Distinguished participants, I can see on the chat box, Emilia asked a question. She says, I'll just go ahead to ask the question, Prof. It says, is a sector where third-party funding and public interest litigation will be useful? I don't know, maybe I should unmute her to ask the question herself, because it's not clear. Or Prof, do you understand?
Good afternoon. Thank you very much.
Should I answer that question, or I should take more questions before I respond?
I think you should answer. You should go ahead and answer the question.
Okay, fine. Third-party funding might be good, particularly who can benefit from that. Basically, for me, I believe the host community. Excuse me. I believe the host community can benefit from that kind of mechanism, perhaps more than the host than the mining company. In this respect, I think the mining company is in a stronger position in terms of balance of power relations. So the host community perhaps may be the one that will need that kind of support to be able to go on. So yes, it's something that can happen, but like I said, we always have to be careful, particularly with respect to litigation, because of the reasons I've already explained earlier, that there could be potential areas of damaging relationship between the mining company and the host community. But the key for me generally is that the lawyer's involvement in this process is to ensure that they help the parties to manage their expectations in such a way that they don't have to resort to this at all. But it's a mechanism that I believe is available. Yes.
Okay, thank you, Prof. Emilia, is this explanation okay for you, or would you want to have more interventions?
No, it's okay. Thank you very much, Prof.
Okay, thank you, Prof. It's really been rewarding today, and I can see the comment section. Everyone is saying it's been intelligent, it's been fantastic, it's been enlightening, and all and on and on. So thank you so very much, Prof. At this juncture, permit me to call on Mr. Ogunti again to take the questions and answer session, as well as recapitulate this discourse as the outcome of the training. Mr. Samuel, are you here? It appears he's not here.
Samuel, you're on mute.
Oh, yes. Thank you very much, my co-moderator. I must apologize for the erratic nature of my desktop screen. I am using my phone as an alternative right now, and I will proceed thereon.
Okay, but I'm sorry, Samuel, you need to mute the other gadgets because it's echoing and it's been aired on live on YouTube. So
Oh, thank you, co-moderator. I have unmuted one of the gadgets.
It's still echoing. It's not just to unmute it, you have to reduce the volume.
Okay, let me reduce the volume. I'm reducing the volume right now. Okay, I'm sure I'm clear right now.
Perfect, thank you.
Yes. The challenge I have, okay, now let me proceed by reading some of the questions that we have. Although I could barely see the questions, but permit me, ladies and gentlemen, to give an outcome of what our distinguished professor had given to us this afternoon, and to corroborate the commentaries by participants that it has been quite enlightening, illuminating, and enriching as well. I must say that the discourse has been a fantastic one. And what are the nitty-gritties that we had imbibed today? Professor has given the lecture on the objective of entering the CDAs, the primary purpose of which is to transfer social benefits to the community. We also have the hallmarks of successful negotiation of community development agreements, which is that there must be adequate representation in the negotiating processes of the community development agreement. And this is to ensure an all-inclusiveness of the members of the community. We also have the obligations imposed on mining companies by law, to the extent of which is that generally they are obligated to ensure that social benefits accrues to the host community, but whatever is obligated on the mining companies must inure to the benefit of all members of the community. And we were also taught on the extent to which CDAs are enforceable, which is that it is enforceable to the extent that there is a clear intention by the parties to the community development agreement to be bound by the agreement. We also taught the dispute resolution process, which is that parties must agree towards the amicable resolution of the disputes that may arise in the course, and which is likely to arise in the course of the community development agreement negotiation processes. Then also where parties cannot effectively resolve the dispute, resort must be made to the minister who is in charge of solid minerals and development. And also where it appears the intervention of minister is not quite successful, parties may resort to the procedures laid down in the Arbitration Act. And ultimately, however parties may agree to dispute resolution, they must be allowed to choose how and in what manner they intend to resolve the issues with regards to the community development agreement. From these neat bits from the lecture today, I would hand over to my co-moderator to read out. I beg your pardon, I couldn't read the comment because my desktop is blank right now. So I hand over to my co-moderator to take any question that may have been asked.
Okay, thank you. Thank you very much, Samuel. There's a question from Max Ikombe, and he's here at the moment. Mr. Max, would you want to ask the question, or I should just read the question?
You can go ahead and read it out. Thank you.
Okay. Okay, so he says, Prof, what of situations where there is intra-communal disputes? What should the MC do? Can the MC deal with one faction of the community? Over to you, Prof. Thank you.
Thank you very much. When you talk about communal dispute here, I expect they come within the qualified community. Now, a qualified community can be made up of 1 or 2 or 3 communities, as the case may be. And I give an example. You have a cement company situated in a particular place because of its the air particulates that come out from the cement activity can affect communities within almost a 5-kilometer radius, as the case may be. So you may have all of 2, 3 different communities as qualifying as the communities that the mining company need to deal with. Now, in such instances, what is expected is that when you are constituting the committee between the mining company and the host community, that committee must be comprised of representatives from all the communities involved, the 3 communities perhaps that I said that are close by and need to be part of this process. So you have them as one group that you are dealing with. Now, the question is that what if community A has a problem with community B? And then maybe you have cited a school at the border between community A and community C for the benefit of both communities, and there's an communal disagreement. Of course, it is not the responsibility of the host community to begin to pick and choose which community to deal with. That would create crisis for the community. In such instances, it's advisable that the mining company continues to liaise with the representatives of the various communities together with the view to getting them to sit at the round table where issues can be decided, can be discussed and resolved. If the mining company sides with one community against the other, it will be creating an unconducive operating environment for itself, particularly later. So the advice here is that the mining company is not in a position to pick and choose which committee. It is better for it to liaise with all. And if it's a benefit that it requires the agreement of the 2 communities to be able to provide, this is one instance where they can hold back and say, well, I'm not going to proceed with the water project until both of you agree. If you don't agree, I cannot provide the water project because I need the concurrence of both communities to be able to do so. So the company should err on the side of caution by trying to wait on such a time that they are able to have the committees all in agreement with the issues to be dealt with. I hope I've answered the question. Ikongwe, have I answered the question, or there's a follow-up question?
Max, are you okay?
I'll just make it a little bit more pointed. So, for instance, in the East, we have a lot of situations with these autonomous communities where there's a land dispute between 2 communities. So, I'm envisaging a situation where the mining license, the land for the mining operation falls within that place where there's a tussle between 2 communities on who owns the land. So, it's a question of who should the mining community deal with, because you don't even know who the owner of the land is. That situation, I don't know what would be best for the mining company to do in that situation.
Okay, thank you very much. Okay, so your question may not necessarily, okay, this is what happens. Being granted a license is a federal thing. The mining cadastral office gives you license signed, but you have to have access to land. The access to land is within state control, as the Land Use Act vests the land in the state, in the governor to hold on behalf of the people. So access to land is a state thing. But the law, the Minerals and Mining Act, does envisage a situation where where you are granted that license, you would now have to access the land. And it says that occupiers of the land or owners of the land need to be compensated. Now, who determines who falls within the area? That is where these are the kinds of disputes that resort to the minister would help. And then the State Mineral Allocation Committee will also be very helpful in this regard in determining where and in which community the license area covers, so that you can liaise with them. So in where a company is in doubt or where there are issues like this, resort to the minister in charge of mines and solid mineral will be the best way to resolve the dispute, because the law gives them that power to be able to deal with issues of that nature. Yes.
Thank you very much, Prof.
Thank you so very much, Prof. So are there other questions?
Yes, please.
Okay, please unmute yourself and go ahead. Yes. Oh, okay, Prof. Please go ahead.
Thank you very much. I know that I will talk, I'll give the vote of thanks, but as part of the Q&A, in the course of the presentation, our very distinguished speaker talked about arbitration being very expensive. I am glad that he is an arbitrator himself. And so, but in the course of his presentation, he raised issues with the attributes of arbitration. People tend to focus on cause of arbitration without looking at other attributes. For instance, when you have a dispute in the mining sector and you have a clause, if a CDA is properly drafted, and the CDA provides that if there's a dispute, there should be 3 arbitrators. One of them should be an expert in mining. The other would be an expert in, say, estate surveying. Another should be an accountant. So when you draft your CDA properly and have a good mix of those who are likely to resolve the disputes, you find that such a tribunal will do better than a conventional court. I have always argued that when you go to court, the judges are like us. They are trained as lawyers. I agree that we are learners. You find that legal training, when we were undertaking legal training, we didn't do civil engineering. We did do mining engineering. So I believe that where you have a tribunal with specialists in the area, be in the tribunal, or you now insist that there must be an expert in that particular area, you find that you are likely to have a better decision than going to the conventional court. And we all know this. The problem of arbitration is not generally arbitration per se, but the personnel, those involved. For instance, we lawyers. Secondly, the judges who are primarily lawyers. You give a very simple award that when you go through it, is faultless. But a lawyer will always tell his client that he can go to court to set aside the award. And he actually goes to court. There are records in this country where setting aside an award has been in the court for 10 years. So I think that if we all embrace the process, i.e., we lawyers are properly trained in the process, and judicial officers also properly trained in the process, we will produce an outcome faster than litigation. So that when you look at time, the value of time, You can start an arbitration in 6 months to 1 year. You conclude a hearing. Again, some lawyers carry their excess baggage in litigation to arbitration and stall the process. You have your first meeting with the parties. You give orders. The orders are not complied with. And you see unnecessary applications. Even in the course of the hearing, unnecessary objections. So for me, not because I'm an arbitrator, I think that for pure commercial issues, arbitration is still better than going to court. So my advice is, when we are drafting the clause, we should ensure that it's not just an open-ended clause, which I mean, you just said that number of arbitrators should be 3. You should qualify them, 3 with qualifications in this area. Thank you very much.
Thank you again, Prof. I think that that answers Emilia's question. She has a
So
second
Emilia
question.
should answer it herself. Emilia should answer it herself. I'll mute her to make it to contribute to this issue.
Prof, thank you very, very much for that invitation. I think I fully agree with you and Professor Akpe. My only concern is I really get concerned when we begin to include specialisms in an arbitration clause. So because again, it might be a simple, straightforward contractual dispute. And as much as we want expertise in the particular subject matter, I think we should want to give parties the freedom to enable them to engage when the dispute arises. So don't forget that there are not that many experts in mining law around. And so that might disqualify quite a few people on this webinar from being appointed in that sort of arbitration. But I think that that is really important to keep in view. So I fully agree. The only other concern I had was, and that was my second question to Professor Akpe, and that's this whole idea of the foreign investor. Because this is an area that is primarily foreign investors that engage with. And we know how incompetent a number of institutions that we have in the country. We know that, how those things pan out. And so my concern, I know that in my own local government area, but this is relevant to the oil and gas sector, and maybe that's part of Max's question, where you have people that are drilling oil, and then they seem to be instigating disputes within different villages and clans in a community. So it's not the example you gave of building a school at the boundary, so you're engaging with 2 separate towns or communities, but within the same town, but different villages. And with the young people, some of the young people we have who are not doing anything, are just collecting money off of the foreign, the mining company or the oil and gas company. How do we do that? Because at some stage, if there is a dispute, and the Navy people or the army or police come and shoot people and kill them, or IPOB, I loved the song you were singing of, yeah. And so you think of what's going on in Imo State and all of those sort of places and IPOB and all of that. What happens to the foreign investor? The problem, of course, is that if the foreign investor decides to sue Nigeria for 10 billion, we're back to square one. It's a huge problem. So I think that we may need to rethink some of those provisions and tighten it a little bit, because yes, there will be contractual disputes, but they may also give rise to investment claims. So that was just my concern.
Okay, thank you very much, Professor Emilia, thank you very much for the comments you made. And I also want to thank Professor Idonije on the way-in he did regarding issue of arbitration. The point for me really, and I asked this question in the course of my presentation, I said to myself, I said that there's a lot of assumptions in the process. The legal regime makes some assumptions that those who are going to be engaging the mining company actually have the best interest of the community at heart and not their narrow interest. And that's why I said sometimes it's not always true. And that's why I gave examples of some community development agreements where the community is asking the mining company to buy. In fact, in one they said the company must buy a Honda vehicle for the chief. To buy a Honda vehicle for the chief. And so you begin to ask yourself, how does that benefit other members of the community? So if it's a transnational mining company that comes into your location and all you are asking for is that your chief should be given a vehicle and his wives be paid some stipend, then it creates a problem in terms of what benefits will go to the community. And that is why I made a point that in trying to choose who the representatives are, care must be taken to ensure that it's an inclusive process that involves all stakeholders, men, women, young population, and all of that, so that when they make a demand, it will be a demand that you can say affects everybody across the board, not just narrow interests of some people. Whether this can be achieved 100%, I think is not, because we are all human beings. We have our interest. In trying to put a community together, for instance, you may have people who are sympathetic to the chief, and therefore they think that the only way they can show their loyalty to the chief is by saying certain things to be done for the chief, as it were. So those things will actually be there. But if you understand the process and you are the one guiding your parties along the process, then it's for you to be able to know that these things can happen. And from beginning to begin to condition whoever you are representing that, look, this is what is expected by the law. Thank you very much.
Thank you so very much, Professor Akpe. Would you want to give them some final notes?
Well, I just said something, and I think something that we all need to know is this. Lawyers representing mining companies, lawyers representing host community, particularly host community, must realize that a mining venture has come to a particular community does not mean that it takes government away from its responsibility of providing social amenities for its people. No, we must also continue to demand that the government at the local level, either local government or state government, as the case may be, also discharge their own responsibility to the populace. If you now insist that everything that you need and require must be provided for the mining company, they will relocate and go to another place where they think there's a better operating environment, and then you would have lost the benefits of that investment, and that you would have been able to have the multiplier effect, particularly on the community, would have been lost. So parties always manage their expectations and ensure that they do not become Oliver Twist in their demands on the host companies. Thank you very much.
Thank you very much, Professor Peter Akpe. Gentlemen, do we have questions, contributions? We have about 37 minutes to go. Make use of this opportunity. I don't know how easy it is to see Prof today that we've seen him for free. Let's make use of this opportunity.
Okay, do I also have an opportunity to ask my own questions?
Oh, I wonder who you'll be directing that question to. Okay, Professor Idonije is there. Yes, sir, please, by all means.
Mute yourself.
Oh, you're muted, sir.
I'm asking this like a test case, or if you like, a negotiation exercise, and then so that we can actually feel what can happen in a particular environment. And I'll ask the question: if you represent a mining company and you are before a community, you are negotiating with a host community that says to the company that, look, we want you to build an airport for us. what would be your take? I think I want to extend my question to Joy Additional if she's there. Yes. Is Joy Additional there?
Oh yes, and I've asked her to. I've tried to unmute her. So.
Sorry, the question again. I set aside. Sorry
Yes,
about that.
the question is that you represent a mining company that is carrying on activities in a host community, and the host community is demanding that before they commence their operations, they must provide an airport for them.
I represent a community.
Yes, you represent the host community, and their demand on the mining company that an airport be built for them. What would be your take?
I don't think that is the responsibility of the mining company, because the responsibility of providing an airport, I think, lies squarely with the federal government. It's one of the things it has to provide for its citizenry, not that of the host of a mining company.
Okay, but what if the host committee is not asking that the mining company provides scholarship for the chief's son to study in Scotland?
For the chief's son to study in Scotland, just like you mentioned at the beginning of the presentation of your paper, if the community, members of the community feel that, well, this chief's son studying abroad or in Scotland is what will bring them joy. Oh, well, the host community can provide, the mining company can provide the scholarship.
So you, as the lawyer for the community, you'll be telling them, look, this is something that you should actually ask for from the mining company?
It is not something they should ask for, but if the community people says they should ask for it and that will make them happy, oh well. If it's their instruction, is included in the agreement.
No, these are the negotiating stage. We are negotiating right now. And what if the mining company does say that, well, okay, yes, we can provide scholarship, but not to Scotland. We will send the chief's son to Federal University of Technology, Mina, for instance. And so that's the offer from the company. How would you advise your community?
It is still a negotiation.
Yes. Joy, are you still there?
Network, the bandwidth is really
okay. Ikongbe, would you like to weigh in on this?
Thank you, Prof. Yeah, it will be interesting, but Prof, following from your presentation, if I were advising, for instance, the mining company and such requests are made, I believe I would be advising the mining company to turn them down, because like you mentioned, going by because this is a statutory contract and by the terms of the law, the benefits ought to be benefits that indeed are conferred on the entire community. So benefits that are.
But Max Ikongbe, here this guy is a crown prince that, if he's properly educated, will come back and sit on his father's throne, and with benefit of good education, be able to cater for the community's need. Don't you think that is important? And in any case, providing scholarships is one of the things that the law says that should be included in a community development agreement.
Well, maybe on that footing, but I'm worried about the conditions attached, saying it must be Scotland or a particular location. So I'm thinking those could be negotiated down to say, look, yes, you could provide a scholarship, and the prince is entitled to be one of the beneficiaries. But I think there should be leeway because, of course, the mining operation itself would be maybe not too profitable. There could be a dip in productivity, and also I think it's always good to negotiate and provide leeway and not make specifics like a brand of vehicle, particular school, or particular location of education and all of that. So I'd always want to negotiate and leave room.
Okay, yes, thank you, because it's at the, I told you that this is what the law expects, but in reality, you probably come across situations where they're not exactly on all fours with the law, and therefore the ingenuity of the lawyer must come in here. Now, and that's also the point I made mention of, that you must focused on the objective. What is the objective? The objective is to educate a member of the community. Now, if the community says we want this education to take place in Scotland, and you say, well, yes, that's fine, but right now the resources of the company cannot accommodate that, but we will educate the child nonetheless in Nigeria in a school that can provide similar education. I think that is a basis for, so the idea is that when you have demands made by the host community, it may not necessarily be their wants, it may necessarily be their wants and not their needs. And so in the course of negotiating, you have to make them to focus on what they really need and not just what they want. And so you will say, it's education you want, and I can provide education in Nigeria in a place that it has that capacity to provide education. And so you'll be able to negotiate along the line. That's the point I'm trying to bring out from that exercise, is that parties should be able to negotiate and manage the expectations of people. What is the expectation? The expectation is that you want the child to be educated in a, if you like, in a high-class educational setting. Good. Scotland, yes, but Federal University of Technology in Nigeria cannot be said to be a bad place to study anyway. So this is the way you can go back and forth in your negotiation until parties agree in respect of something that they can really deal with. And that's why I asked the question, so that I can elicit some of this comment, because these are real life situations. Like I gave you examples. What if the host community is saying that we will be providing security for the company so that nobody goes in, but for us to be able to do that, the company must be paying us 500,000 every month, because if they invite the police or civil defense, they will still have to be providing welfare for them. So give us 500,000 every month to provide security for you. Would you say no, or you would say yes? I throw my question to Omo Osage Joy. Omo Osage. Can you unmute Omo Osage to weigh in? If she's not available, can Benedicta? I'm a feminist, sorry. Okay, Omo Osage, you'd like to speak?
Yes, please, Professor. I would like to hear the question again.
What was the question?
I didn't get it, please.
I actually forgotten the question myself. I said the question was this. The question is that if the host community demands that the company should pay them 500,000 monthly to provide security for the company, and you represent the mining company, what would be your take on this? Would you think it's a good or a realistic offer, or whether you should say, no, we don't, this is too much, we can't pay this?
Yeah, from what you've said so far, I think that is not realistic. It doesn't sound realistic, 500,000. My thought would be that there should be a coming together. I remember the point where you mentioned, talked about a standing committee and all of that. So there should always be room for them to, there should always be room to sort out such situations where it's quite, when it's that.
Yes, sorry, Joy, let me ask you, the point I'm trying to make is that the request from the host community is for the mining company to pay 500,000 monthly to them to provide security for the company. Now, I'm asking you, if you are advising the mining company, whether you think this is a realistic demand that the company can accommodate, or when you speak, are you worried about the quantum rather than the fact that yes, it's something that is doable, but the amount of money involved is too high? What's your take, really?
Okay, it's on both sides. It's doable, it's logical, but the amount of money is also high. So having the host community, having the host community provide security makes a lot of sense, to the extent that they're within, they know the place, they know what happens around there. So providing such is very, very is reasonable. But we'll also have to look at the cost on the company monthly. That's my concern.
Okay, the last question. Thank you very much. The last question I want to ask is this. The mining company A is investing in host community B, and in the community development agreement, they agreed that they were going to provide electricity for the community. And 3 years down the line, no electricity is provided. The company is complaining that their operations are not profitable. The host community is saying, you made a promise to us, you must deliver on your promise. And so they want to enforce the community development agreement. If you are representing the host community, what measures would you take? I don't know who, Obanye, Benedicta Obanye, can I invite you to weigh in on the discussion? Yes. If she's not there, can any other person weigh in that they want to on this discussion? Okay, Obanye,
let me say something, Prof.
Okay.
Zogechi Abu, yes,
okay,
sir.
Okay.
So thank you so much, Prof. It's been a very most enlightening discussion so far. When we're talking about the terms of the CDA, you had mentioned flexibility, that we should be, as counsel, we should be, as lawyers, we should be mindful of flexibility. Sometimes you make an undertaking and then it's practically impossible. So I think that in a situation like that, we can resort to the committee, which of course comprises of representatives of both sides, and to see whether an alternative project can be preferred. Particularly because on both sides, both on the part of the company and the host community, everybody needs to make an effort to ensure that there's a harmonious, because it's a symbiotic relationship, essentially, It's not just the company that is making money, the community is also benefiting as well from the activities of the company in their community. So I think that there should be flexibility on both sides to, focus on the objective and then try to reach a compromise.
Okay, thank you. I don't know how much time we have. Do we have more time?
Yes, we have 13 minutes.
Okay, good. So, Ogechi, a follow-up question would be that, yes, what you have said goes to the issue of flexibility and issue of adaptability. Now, assuming that the parties have gone past flexibility and adaptability, really now they want enforcement. You promise this, you must give us this. What are the dispute resolution mechanisms that you think you can adopt? Which one would you think you can adopt in this particular situation to deal with the crisis?
I think because we discussed about 4 stages, since amicable resolution has failed, that is settlement, discussions, and negotiation. The next would be to proceed to the authority. In this case, that would be the Honorable Minister for Mines to look at it and all that, we are hoping that it can be resolved at that stage. If it doesn't, then maybe we can consider arbitration, taking into consideration all of the costs.
No, don't do it. We don't want a dragnet. We ask which one will best deal with this situation, and your answer, you think, is the administrative intervention of the minister is best in this circumstance.
Yes, that's what I'll do.
Okay, now, Agoma, do you agree with this? Onyinye, do you agree with this suggestion by Ogechi Abu? Can she hear me? Okay, if you are not, I'll go to Opanachi Samson, do you agree with Ogechi on this?
Yes, Prof. Thank you very much. I think I agree with her suggestion.
Why? There must be a reason.
Yes, I think the appropriate authority, first of all, we have to seek administrative remedy, as you said, by taking the matter before the Honorable Minister. Then if the matter cannot be resolved at that stage, then I think then arbitration can be, should be, explored.
Okay.
Yes.
Yes. Thank you very much for that. And I would now hand over to the Secretariat, our moderator. I have done what the teachers do. You get a feedback from the students. And I guess I'm satisfied that at least we have followed the discussion and we understand the issues as it is. It has, for me, it's very fulfilling that we are able to talk about this, and through the interventions, I can see that yes, our colleagues appreciate the issues and they're dealing with it in the manner in which I expect them to do so. So I will hand over to the moderator. Thank you.
Thank you very much, Professor Akwe. But then Max has one more question here, and I'm sure you've seen. Oh, Prof, you're muted again.
Yes, what's Max's question?
He says, if the community prevents the mining company from functioning, can this amount to a breach of standards of protection under applicable BITs and IIAs? You're muted again.
We go back to the issue of investor-state arbitration or investor-state dispute. If an international mining company is involved in this process, and it's coming from a jurisdiction in which Nigeria, where they have a BIT with Nigeria, and this would certainly be, I'm assuming, and I think that would happen, that mining would be one of the qualified businesses for which the BITs would protect. And so if they start business and you do not allow them to continue, in that it could be a way of saying that they have been prevented from carrying on their businesses, in which case if the state authorities, particularly in Nigeria, is not able to provide the company with the necessary remedies by granting it, enabling it to be able to have access as required, then Nigeria could be held to be in breach of its obligations under the BIT, and this could grant an action, an investor-state dispute, as it were. But the point for me really is that even before we get to that stage, where the companies prevent the host community, where the host community prevent the company from discharging its responsibilities, I think it's incumbent on the minister who granted the license in the first place to ensure that, having granted a license to some person, that the person has met all the obligations on that license, that an enabling environment be provided for that venture to be able to be carried out within that place. So ministerial intervention in this respect, for me, is very key to ensuring that this happens. And the law itself recognizes the primacy of mining ventures. Section 22 of the Minerals and Mining Act does say that you treat a mining venture as an overriding public purpose within the meaning of the Land Use Act. So if you have land for agriculture and you are carrying out agricultural activities and I get a license over the same land, the law says that I should be given the priority of use of that land for mining purposes. And in fact, it is considered an overriding public purpose for which, if any other interest is there, the governor can revoke to ensure that mining takes place. So that gives you an indication as to how the law views the titles given under this act. Yes, sir.
Thank you. Thank you so much, Prof. It's been interesting, and this is an outstanding presentation. Well, with the kind permission of the committee chair, may I at this juncture call on the committee chairperson in the person of Professor Paul Idonigi to give the vote of thanks.
Thank you very much, Audrey. Let me make a plenary statement. Attendance is now 31. I must confess that I'm not happy at all. If we have to organize training for less than 50 people, Abuja Bar is second largest in Nigeria. I don't think it's encouraging. Perhaps we should stop for now until through the chairperson, the Unity Bar tells us that there's interest in this area. As you can see, Professor Peter Akpe, SAN, is a leading authority in this area. In fact, his doctorate degree is in the area of mining law. So we're not bringing speakers who are just academics. We are bringing speakers who have hands-on experience. We thought that the branch should share from our experience. But if attendance is going to be this poor, like I said, maybe we have to rethink how often. Maybe we'll do the presentation once in 6 months or once every quarter. For instance, Professor Emilia Onyama will speak to us. Well, he's been to speak to us in July. But if attendance is this poor, even though it's virtual, it's no use bringing her from the UK to talk to 3 people. I am not impressed. I'm not impressed at all. But I thank Professor Peter Akpe for the presentation. Of course, he knows that we expect nothing less from him. He's not just a leading authority by name. He walks the talk. At a point, I almost stopped him from talking because, you know, if we give out too much, the breeze coming to us will be less. So we should have priority in terms of knowledge in this area. But I think he was talking too much, and but thank God he has stopped talking. We are hoping that next month, Professor Akisheye George SAN will do the next presentation. People are lined up already, but like I said, if by the next presentation we only have 30 participants, we will pause. We will pause and do this program maybe once a year or twice a year, as the case may be. Personally, I've gained from attending programs of this nature. Whatever knowledge I have today in terms of commercial transactions, in terms of drafting, in terms of negotiation, because of the kind of training I've had. As you can see, what is being discussed today is not taught in university, it's not taught at the law school. So unless you come for programs like this, you will not have this experience. And like I asked the other time, is it because it's free? Is it because this training is free? We are not that free. We are very expensive. But if there's not enough interest generated, then we'll think twice. But Professor Akpe, thank you very much for making us proud, for doing a good job. Now, let me also add this. You know, some traditional rulers are very powerful. In some areas where you have these mines, some traditional rulers actually connive with the mining companies to appropriate everything to themselves. And if some young men are trying to engage them, they call them rascals, they call them all kinds of names to discredit them. Even the young men on their part, sometimes they are not that organized. You find in a community, there are 2 or 3 groups of young men confronting the mining companies for purposes of negotiation. So it's really a matter that requires skill in managing the environment. So, but I think it needs the cooperation of not just traditional rulers. You know, we live in an environment where our obas, our kings, our emirs are like lords. I know of a community where traditional ruler was getting everything for himself and his family, everything. In fact, he didn't like the mention of CDA at all in his community. And in his compound, I don't know how many cars he had, until the youths one day, when they burnt all his cars. In fact, he ran away from the palace. That's only when he agreed that CDA should be negotiated. So we need lawyers with skills in this area, whether you are active for the community, whether you are active for the mining company. It's an evolving area. If you follow the PIB, community issues is still a major issue. The old, now this is Nigeria Petroleum Act, has no provision for CDA. So these mining companies, they just do the CSR. They just think we just offer you whatever we think we can do. There's no obligation on our part to do it. But with the mining sector, I'm hoping that by the time the PIB is passed, we'll have a stronger part of that bill that provides for CDAs in areas where oil, gas is available. On that note, let me once again thank all of you for coming, but really I'm serious. If attendance is 31, we will stop this training for now until we are ready. I know that the Abuja bar is very large. So if they see, as a teacher, especially as a law school teacher, where I had 1,000 students, I get energized if I come to the classroom and it's a large number of students. But when I come to a room, there are 5 students, I'm weak. So please, I'm glad that the bar secretary is here. Please tell the chair that our committee is not happy if after all these efforts, we can get 31 participants. I don't think we should continue for now until the bar is ready. Emilia, do you want to say something?
Prof, if you don't mind, I think we still have a few more minutes before it's 4 o'clock. Can I appeal to you, Professor Akpe, and to your committee not to take that view, simply because ultimately, yes, numbers is important, and I do feel the same way when I teach. I'm energized by the more the better. But at least we want participation, and we want to be sure that those who show up are actually interested and they participate. I have thoroughly benefited from this. I'm actually considering whether I should become a member or leave Lagos Bar and join the Abuja Bar. And so please don't deprive me of that opportunity. It's a lot of learning. And I just want to say, for me, the most impressive point really is that there's lots of younger colleagues. I think that we're building skills and we're building knowledge for the future. I think that's important. So if you take it as your, Professor Akpe, if you people take it as your pro bono work, we will be very grateful. It doesn't really matter. We really, I haven't said, well, yeah, I really think I should join the Unity, but why not? And so please accept us the way we are. The most important thing is it's useful to us. We are learning, and we will share, we'll pass on that information to other people. So hopefully you won't feel too bad. Yeah, pro bono work, why not?
If I may just respond to, hello?
No, I'm almost through, so that you can give your closing remarks on behalf of the chair.
Okay.
I think I'm done. I note the comments by Emilia. I know she will always speak like that. I know her very well, so, but I'm not impressed. I'm really not impressed. Not. So, well, I hear it's a pro bono work, which we agree, we're not being paid for doing it, but that is why we should feel that those who are to benefit really come for lectures. But I take note of the issues.
I beg your pardon, Prof. Sorry, at some point we actually 67. I kept monitoring. I'm not saying 67 is a whole lot, but maybe that will help suit you a little bit.
It's okay. Thank you. Well, once again, Professor Peter SCN, thank you very much. I now hand over to Prince, who is acting on behalf of the branch chair. Thank you very much.
Thank you very much, Professor. I don't even know where to start from now, but I think the place where I would start from is to also tell the committee the feedback we have been getting, especially from the last program. We have had a lot of people send in letters. We have had a lot of people call us to applaud the work of the committee. And if there's anything to go by, sir, your committee is one of the committee that has really gone outside the box to bring value to the table.
We are not comatose again.
So you tarried for a while before you started, and when you started, in fact, you have chased almost every other committee out. I understand that it can be very discouraging when a lot of effort has been put into organizing this kind of webinar, especially with the kind of resource persons you are bringing. And we are also privy to the kinds of resource persons that are on the waiting list. Professor, what I can just say on behalf of the branch and of course my chairman is that we are going to take this up very seriously. Our meeting is coming up on the 5th of May, and this is going to be something that will be pressing on very seriously to our members. And then, just like my assistant secretary said, I am also aware that we have over 100 people registered, but I did not know how at some point the participants became 31. But it's something that the feedback that we are working on. And if I don't know if you have been following our platform, we have never publicized any program like we are publicizing this one. We send it out 3 times, sometimes in a day. And we've been doing this consistently for 1 week. And then what I can say is that we're going to put more effort. And then please don't be discouraged. We are very happy to have you this committed to the work. Thank you very much, Leonard. That's with respect to the remarks. But on the whole, we want to thank everybody. We want to especially thank Professor Akwe. It has been a very, very explosive time. I was following it, and I was jotting down a lot of points. I used to think I'm a pro in this area, but hello.
Please go ahead. We can hear you now.
Oh, okay. So I want to thank every member of the committee chair, the secretary of the committee, my able assistant secretary who has been behind the scene making sure that everything is going on very well. And to all the participants, please let us keep the fire burning. We're very grateful. Thank you so much for this second session of the program. We're grateful, sir.
Thank you very much. Thank you.
Thank you.
Thank you so very much, everyone, for following this invitation today. We honestly hope that this dialogue has sufficiently discharged the essence of this concentration today. Again, we appreciate our erudite speaker and our speakers, distinguished gentlemen of this noble profession, the executives, the executives of the Committee, Continuing Legal Education, who put together this credit-based training, the rapporteur and co-moderator, and to all you awesome guests for participating in this outing today. Thank you so very much for the success of this training. The slides, the presenter slides will be sent. It's actually on our website as we speak, but then it will be sent alongside the previous speaker slides to the platform. And then the certificates will be posted on the platform when it's ready. I remain your go-to person, Chinelo Audrey Ofebunam, the Assistant Secretary of the branch. Thank you, thank you, thank you. See you in a minute.
Okay, bye-bye.
Bye.
I'll just stay back because it's being aired on YouTube and it's not at the same time, so that every other person there can watch. Oh, my apologies, Johnny Agim. He raised his hand at some point and I said I was going to call him. I'm so sorry, sir. Please, you still have the floor, even though the program has ended. Professor Donige is here and Professor Ape are still here. Please go ahead. I just unmuted.
Don't worry, my dear. Don't worry. It's okay.
Sorry, sir.
I really enjoyed myself. I sent a comment there that we are following, even though I'm at the mechanic workshop. But it's okay. Yes.
Okay.
Thank you very much. Thank you very much.
Professor Akpe, thank you so very much. It's a success. We appreciate you. Professor Paul Idanige, thank you too for everything, for all you do for the branch.
Thank you.
And please don't be discouraged, sir. Can you see the comment section? Everyone is saying, sir, no, 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 no. So please don't think of it too. If you disappear, who will come and who will chair your committee, sir?
There are many fit and proper members that can drive this process.
True. We are not disputing that, sir, but please, we need you.
Thank you.
We need you here.
I'm not allowing you to
Thank you so
retire.
much, sir. And thank you for. Sometimes you call, you send me messages at 12 midnight, and I wonder whether you ever sleep.
Well, I do a lot of night shift.
Okay.
Yeah.
Thank you,
okay.
Mark.
So we wait for Professor George SAN for his presentation next month, then we'll fix a date.
Okay.
But in June, we're having Professor Ofonze Amuchaize SAN.
Oh, okay.
Yes. Then Emilia, and we're looking for somebody there for August, which Professor Akpe is working on.
Okay.
If we are encouraged, we'll just line up every month till December.
Don't worry, I take it as a challenge now. Mad publicity.
All right. Okay.
Mad publicity going forward.
Thank you very much. Okay. All right.
Thank you, sir.
Okay. Bye-bye, everybody. Yeah. Okay.
Bye, sir.
Bye-bye. Yeah.
Well done, Samuel, and well done, Audrey. I think this has been a wonderful session.
Thank you,
and
sir.
I see streaming on YouTube as well, so it's good. Well done.
Thank you.
Max, how are you?
Fine, thank you, Prof.
Okay.
Wow, Prof, it's been a delight. This has been a wonderful session, and I believe it's well worth it. It's because for me, I love the way Prof. Akpe was able to break down CDA step by step. You know, it's something I've heard about, but I've never really followed properly this way. It's wonderful.
Because of people like you, I think there'll be some fee now for attendance. It's not going to be free of charge.
Very well, Prof.
You know, we are not in the class of teachers whose rewards are in heaven. We're asking for part payment. We're asking for part payment here.
I will know you're joking.
Yeah, so advance on the payment that is in heaven to be drawn down on account.
Yeah. Okay.
Thanks
all
so
right.
much.
Okay. Bye-bye. Bye. Okay.
MBA, thank you so much.
Thank you, Deborah. Lovely picture, by the way. I'm going to steal this
Thank
down.
you. Thank you.
Laura, thank you. Sam, you've been awesome. Thank you so much.
Please, if I may request the YouTube link, someone asked for it. I don't know if we can make it available now.
Yeah, I'll just
if it can be sent to me.
Yeah, I'll get it and post it now on the platform. Okay, so I've just posted it. Can you see? Can you see? Sam, can you see it? I just posted it on this
I'm
platform.
trying to.
Oh, you want me to send
I've
you?
exited the screen, but I'm trying to reconnect.
Okay, but which one are you?
Okay, you
I'll
may
just
send
send
it
to you
personally.
WhatsApp. So please try logging in now to see if it's the correct link I sent to you.
Okay, I can see it now. I've copied it.
First Lady, thank you for logging in and staying from the beginning till this time. We love you. We appreciate you. Please don't forget to log into the next one. Your head prof is going to be What's Your Wow. Her Excellency, I guess she just logged in and stepped out. Whoa, Sam, it's been crazy today, from one meeting to another. I'm sure you noticed that at some point I was in the car.
Yes, I did. In fact, you were able to switch anyway because of the presentation. So you would have time to hibernate, then resurface again. At the point I saw it, saw you in the car, and you were following and speaking at the same time. Well, God will reward you. This is just the little bit we can do for the betterment of the bar.
Right? We don't have a choice.
It hasn't been easy. God is your strength. Thank you very much.
Engaged while we are young, because there'll be a time where we'll be able to do all this. We have to make up for this time.
Exactly.
All right, Sam. Thank you. You've been awesome. Look forward to working with you again. Time in May.
Me too.
All right.
And if Jesus tarries.
Yes, he will. He most definitely will.
What if he doesn't? What if he comes there?
No, he will. He will. Okie dokie. So I would leave now.
That's true, man. All right. Have a great day.
Bye.